No, he's still in custody now.
Yes, my lords. And in fact, my lords, when the
Statement of objections.
No, no, what is this, madam? Somebody is in custody, you're going on taking time. This can't be at all. Now somebody is in custody. You go on taking time to file objections. How is it?
200
No, no,
my
what
lords,
is this?
270 days to now, 270 days is in custody in a case which is punishable up to 7 years. .1 is a custody matter, bail matter, my lords. In an PM, this matter pertains to Muda, my lords.
No, he's still in custody now.
Yes, my lords. And in fact, my lords, when the
Statement of objections.
No, no, what is this, madam? Somebody is in custody, you're going on taking time. This can't be at all.
can I point out in that matter
8th of June, my lords.
the
Kindly-
liberty?
Nimsha, madam. Now you see this matter. No, it's not the person XYZ. Now somebody is in custody. You go on taking time to file objections. How is it?
Let's kindly have
200
it,
No, no,
my
what
lords,
is this?
270 days to now, 270 days is in custody in a case which is punishable up to 7 years. My lords, I'll point out the liberty granted by the coordinate bench, my lords.
Page.
Please notice the order of the coordinate bench when the bail had been rejected. It was on 20th January 2026, page 346. 346.
Bail reject aita ondsari.
On 20th January 2026, with liberty, my lords, to approach this court in 3 months' time.
Back in 3 months' time.
Howd. My lords, may
340?
notice 346, 20th January 2026.
343 last page.
346. It comes, I think, in the next volume, my lords. 346.
ಮೂರನೇ ವಾಲ್ಯೂಮ್ ಇದೆಯಾ?
My lords, we may be given
Three.
some time for
I'll
seeking
just point it out.
Madam,
Just to
let me see that order. Wait.
Yes.
kindly notice 346, my lords, annexure E. Various grounds that were urged when it came to the aspect long incarceration, my lords, the court would take notice of that.
Page.
346, the order starts.
No. Where is that observation?
11th, yes, my lords. Just may I point it out. At page 388, Roman number 7 may be noticed, my lords. 388.
Long incarceration.
And delayed trial as consideration for grant of bail. The court considers Manish Sisodia, my lords.
Correct.
And after that, the liberty which was given, at that point of time, it was about 127 days of custody, my lords, when this was rejected. My lords may notice at paragraph, at page 411, paragraph 88 may be noticed, my lords. 411, paragraph 88, before the conclusion. However, taking note of the length of incarceration is 127 days as of now.
Cannot be released
Yes,
for bail for present.
Then, conclusion, Manish Sisodia is considered
All
again.
right. Alla 3
And-
months ಬಿಟ್ಟು ಬರಕ್ಕೆ
Yes,
ಹೇಳಿದೆ.
my lords, and page 413, 413, just
Reserved
above,
liberty to the appellant to move fresh application in change circumstances, proceeds at snail's pace in the next 3 months, or if the trial is not concluded within 6.
Now-
What was the date of this order?
my lords, 21/2026.
20th January 2026.
Yes, my lords, we
So
are
6
still
months, 6 months are over.
3 months. The liberty is 3
Liberty
months.
ಅಲ್ಲ ಇದು ಈ ಆರ್ಡರ್ ಯಾವತ್ತಿಂದು?
January, ಈಗ 6
ಅದನ್ನ
months, ಈಗ 6
ಕೇಳಿದ್ದು.
months ಆಗಿದೆ.
2026.
ಹೌದು.
So court permitted 3 months time.
3
Now
months,
it's
92
Now what's
also
the
may be
stage of the
noticed, my
trial?
lords. Paragraph 92,
Stage of the trial.
stage of the trial, only cognizance taken, no progress at all. And in the meanwhile, my lords, supplementary complaint filed, 3 accused in the supplementary complaint, it's at the stage of pre-cognizance because notice is to be issued to them. I mean, like, there are about 8 changed circumstances which are there, my lords. It fits into what has been given as the liberty. May I just point out the 8 circumstances? In the predicate offense, my lords, default bail in the predicate offense, 16/3/2026,
Granted.
granted. Then charge sheet is filed in the predicate offense on 16/3/2026. Cognizance taken by the trial court in this as against me on 24/4/2026. Supplementary prosecution complaint filed against accused 2 to 4 on 28/3/2026. We are still at pre-cognizance stage there. Those supplementary prosecution, those accused not arrested, my lords. The 3 accused were never arrested, co-accused. I was the only one who was arrested in this whole case, and virtually, my lords, I stand on the same footing as Natasha. He had same, my lords, and it was quashed against him.
Supreme Court confirm ಆಯ್ತಾ?
Howd.
That is also
My lords, adರಲ್ಲಿ out of 2 matters, 1 appeal and 1 went to the Supreme Court. Supreme Court SLP was rejected.
no, where I wrote, I think that is confirmed Supreme Court.
Yes, my lords. Yes, my lords.
that
Which was
Parvati's
written.
case.
Yes, my lords. Which was written by the coordinate bench. Appeal was filed. Appeal is pending.
Appeal is still pending.
Pending. What my lords wrote was under 482. SLP filed. SLP
correct.
rejected. So virtually that has to be followed in the. It's not come up, my lords. In that same matter, my lords, allegation against Mr. Natasha was that he had allotted certain sites. His successor is this person. He had allotted some sites. That is all was the allegation. It is quashed against Natasha. That's why the connected matter here is the 482 for quashment. So, my lords, the other
So you want me
aspects,
to follow Natesh's judgment and quash it,
he stands on the same footing. I'll be able to demonstrate. my
except
lords.
the operative portion.
Anyway, my lords, so far as bail is concerned, now, my lords, in a matter which is punishable up to 7
No,
years,
this bail
270
is not
days,
correct,
if a person is going to be in custody, my lords. And that's the reason court reserved that.
What's the offense?
Under 4 of the PMLA Act, up to 7 years. That too may extend, my lords,
Now,
may
on one
extend to
short
7
date,
years.
my lords. Senior would be appearing as such.
I know, I understand, but this is not correct, madam.
Please, please.
And now, my lords, the Supreme Court's recent ruling on bails, my lords, again,
No, this bail definitely has to be considered.
This, my lords,
Washment ಗೆ ನೀವು ಕೇಳಿ,
my lords,
the
idralli,
last 300 days somebody is in prison.
lords, an amicus was appointed. My lords may notice 3.10, the appointment of amicus. And then, my lords, the next page, paragraph 4, the analysis. Please notice bail applications, my lords, in that table. This was given by the amicus, bail application. Bail application should be heard, orders pronounced preferably on the same day or on the next day if reserved, and must be uploaded promptly. Then the directions we get at paragraph 16, my lords, paragraph 16. My lords, paragraph 16, capital A, small b and c may be noticed, my lords. Paragraph 16, capital A, under which B and C deals with bails. And in 3 months, we were given the liberty. Now it's 6 months, my lords. He's still languishing in jail.
Tuesday morning is the first matter.
Please, my lords.
Yes.
of life.
Heard the learned senior counsel, Sandesh Chowta, appearing for the petitioner. The learned counsel representing the learned ASG seeks seeks short accommodation. Less the matter on Tuesday. It is made clear no further adjournment would be granted in the bail matter in particular.
Of life.
Yes. Objections ಏನು ಬೇಕಿದೆ? ಅಲ್ಲ, what objections?
We have come on the basis of the liberty and we are able to demonstrate we have not progressed at all, my lord. No likelihood. And the documents are running up to about 11,000 pages.
As the hearing progressed, the court examined a bail plea filed by an accused who has spent nearly 270 days in custody in a case under the PMLA. The defense argued that although bail had been rejected earlier in January 2026, the court had granted liberty to renew the request if there was no meaningful progress in the trial. 6 months later, counsel pointed out that the case still remained at the cognizance stage, with the trial yet to begin. The petitioner's side also highlighted what it described as significant changes in circumstances. It was argued that default bail had since been granted in the predicate offense and that supplementary complaints had been filed against other accused persons who were never arrested, placing the petitioner in a different position. Relying on Supreme Court principles concerning the right to a speedy trial, the defense urged the court to consider the prolonged period of incarceration. Taking note of these submissions, the court treated the matter with urgency and directed that the bail petition be listed as the first case on Tuesday morning. The bench further made it clear that no further adjournments would be entertained, signaling the need for an early decision on the petitioner's plea.